And hello, everybody, and welcome to a special edition of Beach Talk Radio. It is a Wednesday night, and we're broadcasting live from the home studio tonight. You have just me this evening. Our topic tonight is something that's been going on down on the beach for a while. Jim Jameson is involved in a lawsuit with the town. He's been battling with them for quite a number of years now. So we decided we'd bring in his attorney, Ryan Reese, who is in Tampa. And Ryan, thanks for coming on. First of all, we appreciate your time.
Sure. Appreciate you having me, Ed.
So, Ryan, can you kind of back us up a little bit and give us some of the history of how Mr. Jameson, got involved in this situation with the town of Fort Myers Beach?
Sure. Jim engaged our office in late 2015, coming off of a series of development denials of applications that he had made to the town over the course of the previous 4 years. Each seeking to appreciate some use of his private property there on Fort Myers Beach. By way of orientation, Jim owns 40 platted lots that are separated into 2 tax parcels right there at the terminus of Mango Street and just east of Chapel Street, just southeast of the business district there. By way of orientation, if you find the town hall, Fort Myers Beach Town Hall, and you go about 250 feet to the northwest, those are the 2 vacant parcels that Jim owns. And so he purchased the property back in 2002 and almost immediately sort of had some government mishandling of the property. Purchased in 2002 with a business partner, and almost immediately thereafter, the Fort Myers Beach Town Council issued a resolution unilaterally saying that they would not entertain any development on the property, and that they urged any permitting agencies, including the State Water Management District and the Department of Environmental Protection, to deny any and all development endeavors that Mr. Jameson would submit. And so, that was hanging out there. He did engage local land use council, and over the course of about 2010 to 2014, made several development applications to the town to try and appreciate some use on this property. It was, again, 40 platted single-family residential lots. The town had, and it was a carryover from Lee County, had delineated the property as wetlands on its comprehensive plan. And there's a little history to that, if you don't mind me getting into it, Ed. Mosquito ditches had been dug on the property by the Fort Myers Mosquito Control District back in the 50s and 60s. And those ditches created or produced some wetland habitat on the property. Wetland habitat that we contend was wholly man-made. And so when comprehensive planning became mandatory in the 1980s, Lee County, who then had jurisdiction of the property, identified the property as wetlands because it had ditches on the property. And that was sort of the future land use that it had signed. And when the town incorporated in 1995, they carried over without any environmental scrutiny or science whatsoever that wetlands future land use designation. And it's just sort of become this common perception that the property is just wetlands without, again, any wetland delineation, science, or study by either Lee County or the town of Fort Myers Beach. And so in 2010, Jim went out and had a wetland delineation of the property done by the entity responsible for performing those, the DEP. And it came back and determined that only 61% of the property had wetland characteristics, typical, again, of having that property feature introduced from the mosquito ditches. And that 27% of the property was actually developable uplands, and 12% of the property was other surface waters that are also developable based on mosquito control exemptions that exist in the Florida Administrative Code. And so in 2010, early 2011, Jim presented that delineation to the town, saying that, you've identified this property as wetlands in error. Please, change it. And the town refused to do that. And so then in 2011, he applied to the town for what's called a minimum use determination, which is basically a determination by the local government authority of the absolute minimum use you can appreciate from your private property. It's essentially, in layman's terms, all other things being equal, if you can't do anything else on the property, we'll let you put a single-family residential home on it, is that property's minimum use. In that application, he sought a minimum use determination for all 40 platted lots, and that application was denied. Then in 2013, early 2014, he applied. At this point, thinking it was futile to actually try and develop the property, applied to the town for a comprehensive plan amendment to strip the density that existed on those 40 lots off of the property and bank that density in the form of TDUs, transfer of development units, transferable development rights. And that application, though it was met favorably by town planning staff, was ultimately denied by the town council. He then appealed his minimum use determination in late 2014, and the council, I think probably to avoid a litigation at that point in time, actually granted him a minimum use determination for all 40 of his single-family residential platted lots, effectively saying that the property qualifies for a single-family residential minimum use. And so with that entitlement, he then proceeded to apply for a variance from a land development code provision that precluded construction in wetlands classified property, which was also denied. And so he engaged our law firm shortly thereafter to see if he could vindicate his constitutional and private property rights in the court.
So what was the original reason that the town gave to deny what Jim was trying to do? Did they give a reason?
Well, it's complicated. There were several reasons. A lot of it has just been sort of I think this is the way that they've always thought the property was wetland. Lee County called it a wetland. The town of Fort Myers Beach called it a wetland. They seem unwavering in wanting to identify it as an undevelopable wetland, even though that's been proved untrue at the state level. They've just called it a wetland. And the way that the town's regulations are written, you are unable, with the size of property that Jim has, it's roughly 7 acres, you are unable to appreciate any use, any economic land use, i.e. construction, in wetland classified property. It's very strict at the town level, and it's non-discretionary. And so, the town has essentially taken the position that Jim has never had development rights in the property because he bought the land after it had been what we argue incorrectly delineated, and thus, you sort of take title with notice, and you never had any ability to appreciate use on the property. And we think, go ahead.
Did Jim know it was wetlands when he purchased the property? I mean, did he get hoodwinked into the sale?
No, not at all, because in fact, the property, at least 39% of the property is not wetlands. And the state delineation says precisely that. And there's a stigma associated with wetlands. There's varying degrees. There's pristine wetlands, which the state, has issues with you impacting in terms of development. And then there's man-made wetlands. And there's exemptions at the state level for wetlands that are man-made and wetlands that are exclusively created from mosquito control activities, which we contend is what the Jameson property wetlands are. That they were created and introduced to the property simply from the ditches that were dug in the 1950s and 1960s. And in terms of the smell test, Um, the best way to think of it is look at the county property appraisers GIS mapping. Look at an aerial of the Jameson property, or look at an aerial of the beach. I mean, there's no other wetlands around the Jameson property. It's fully built out. You've got varying uses, residential uses, commercial uses of varying degrees and intensities that surround Mr. Jameson's property. And so that's sort of been the scrutiny that we've given to this, is why has he been singled out as a landowner who can appreciate no development at the town level, when all of his neighbors and landowners that are similarly situated have been allowed to develop their properties fully.
So what is the reason the town gives for not allowing a house to be built on that 39% or whatever the percentage is that isn't wetlands? Or is that just because the whole thing's in litigation, he doesn't even want to do that?
Well, the future land use designation of wetlands exists incorrectly, I would submit, over the entire property. And the town's comprehensive plan and land development code makes clear that when your property is delineated wetlands, you are not allowed to, in all essence, move earth. You are not allowed to place fill. You are not allowed to do construction. It's you basically have to leave the land in its natural state. And so that's the reason. That's what their regulations say. And that's what they are required to follow until those regulations change.
So has there been any litigation up to this point? I know we have something coming up on August the 18th in front of somebody who we're getting very familiar with on the beach, Judge Laboda. But has there been any litigation up to this point?
There indeed has. This property has been in litigation since 2015. We filed in late 2015, early 2016, a Burt Harris claim with the town. It's a pre-suit claim that you make prior to engaging in litigation with a government entity. And we let them know that we had issues with the way they had applied their land use regulations, insofar as they had precluded Mr. Jameson from appreciating any use on his property. And the claim was made as a pre-suit requirement, and then it did indeed transition into litigation in 2016 when we filed the complaint. The case has since been litigated and pretty heavily. We moved almost immediately at the start of the litigation for a summary judgment on Jim's behalf. Summary judgment is essentially asking the court to rule in your favor on one of your legal claims. Here we raised the unconstitutional takings claim, having the judge rule without a trial, basically saying that the facts are not in dispute. We didn't think at the time that the regulations, the plain text of the regulations, were in dispute. The town had made at that time numerous admissions saying that they would not allow the property to be developed, basically saying it was undevelopable. And we moved for a summary judgment on our takings claim, saying that it was under United States Supreme Court constitutional case law impermissible to deny an owner all economic use of his property. The town had arguments against that and cross-moved for summary judgment on their own sort of predicate legal defenses. The court in 2017, I believe, sided with the town and determined, the trial court determined that Mr. Jameson had essentially no development rights in the property because he had bought it with notice of this wetland land use regulation, constitutional or not. He had notice of it and was basically sold out of luck from challenging and trying to appreciate development. And so we had to appeal that decision to the Second District Court of Appeal up here in Tampa, a panel of 3 judges who reversed the trial court's determination, finding that Mr. Jameson did have full rights in the property to challenge the wetlands designation and the application of the town's regulations to his property, and that the argument that he bought with notice just was not the law. And so we were remanded from the appellate court. That opinion was issued in March of this year We were remanded back down to the trial court with instructions on the correct law to apply, and would proceed then towards the trial. We then moved immediately again for summary judgment on the takings claim, asserting that the town had impermissibly denied Mr. Jameson all economic use of his land by virtue of its regulations, the application of its regulations, and that was under United States Supreme Court law an unconstitutional taking. And so that is set for hearing here in August, I believe August 18th, coming up next month.
So what? So the district in Tampa, the appeals court, they ruled that the judge below used the wrong law. Is that how come it was overturned?
So there were two bases for the trial judge's ruling, basically granting judgment in favor of the town early on. The first was that he bought with notice and had no right to develop the property. The appellate court determined that that was not the law, and that the judge was not allowed to apply that to Mr. Jameson's situation. The court also determined that Mr. Jameson had not made a meaningful application to the town to develop the property, despite having submitted 4 prior applications. In the appellate court, it's called a ripeness issue under takings jurisprudence, and so you have to make a meaningful application to allow the government body in charge of implementing its regulations the ability to rule on the property and make a land use decision accordingly, to permit some development perhaps. And Mr. Jameson had made 4 of those, and they'd all been denied. But the court determined that he had not made a meaningful application, and the Second District Court of Appeal overturned that finding as well, finding that he had indeed made meaningful applications, and that any further applications to the town council to try and develop the property were quote unquote futile. There's a body of law on futility, and they applied that exception.
So you said something that we're getting familiar with too, a Bert Harris lawsuit on the beach. When you file a Bert Harris lawsuit, aren't you supposed to go to mediation to see if you can work it out? Did you go to mediation and it didn't work out?
So we presented, our complaint had multiple claims to it, both a statutory Bert Harris claim, which is a claim that the local government has applied its regulations to private property in a manner that inordinately burdens, that's the magic language, inordinately burdens the use of the property. And so that was indeed one of our claims. The second claim was based on the state and federal constitutions that the town had impermissibly appropriated by regulation or taken the property by regulation by virtue of how it has applied its regulations, denying Mr. Jameson of all use. In Lee County Circuit Court, you are indeed required to mediate the case. We never got to that point because the court had ruled against us so early on in the case, and that they were legal issues in nature that mediation would not have been too fruitful. We will likely be required moving forward here to conduct a mediation. But again, the factual issues of this case are not necessarily in dispute. The town's regulations are as they're written. And the way they are written, they preclude Mr. Jameson from using his property. He has applied to the town seeking variance or seeking alternatives to those regulations, and they have denied 4 of those endeavors. The town has admitted in litigation that they will not entertain development of this property, that he had no development rights from their perspective. And so we think that the facts are really not in dispute. And it's for the judge to rule on the decisional law, whether it is permissible for a local government entity to sell a private property owner they cannot appreciate any use of their land. And there is a Supreme Court case out of South Carolina. It's known as the Lucas case. And it's a bedrock of takings jurisprudence that says exactly that. You as a local government have the ability to regulate the uses of one's private property, the use densities, intensities to a degree. That's how we get land use and zoning controls. But you are not permitted to flatly say or flatly regulate an owner out of any and all use of their private property in the name of the common good, which here the name is basically environmental preservation. And that's, sort of a point that I'd like to make. A lot of people think that, Mr. Jameson's just mad about the wetland regulations. There's no dispute that wetland regulations have an important place in zoning and land use controls. But, you're not allowed as a government entity, again, to apply that regulation to eliminate all use. And that's how the town has chosen to apply the regulations here.
So that's where the Burt Harris comes in, as we've learned, right? And so if you get to the point where it's a serious Burt Harris case and it goes to the court for that, what is that property worth, and what would he try to get out of the town for that?
Well, so I think our Burt Harris claim is our second best claim. Frankly, I think our constitutional takings claim is the best claim because it's clear, the law is clear that you're not permitted to press private property into public service under the guise of environmental preservation. And that's what's happened here. You can't say private property owner can't use your property at all in any meaningful manner. And that's sort of what our constitutional count is based on. But the Burt Harris count is equally as powerful. It's saying that, you've got a regulation that you've applied that's inordinately burdened the property. And certainly we think that's happened here. But it's more than just an inordinate burden. It's a flat out categorical denial of any and all use. But as a precondition to raising a Burt Harris claim, to answer your question, Ed, you are required to submit to the government entity, that is that pre-suit process I spoke about, an appraisal of the property demonstrating the loss in fair market value sustained. And here we submitted an appraisal. It is public record, and it is a tremendously significant damage. The property as developable versus the developable with 40 single-family residential lots versus the property as an environmental sanctuary with no use whatsoever. That diminution in value is significant. I believe roughly offhand our appraisal said $7.1 million. So it's the value of 40 single-family fully developable residential lots on Fort Myers Beach versus sheer wetland land value with no ability to be developed.
So just so the residents know, the town would have, if they won, if you won and the town lost, the town would have to write a check for $7.1 million if the court decided that was the right amount, even though they'd get to keep the wetlands.
So it's a little complicated. Takings cases and Burt Harris cases are bifurcated. The first phase of that process is determining liability, and it's determining whether the government entity, by application of its regulations, has taken or inordinately burdened under Burt Harris use and value of the property. If the court, and that's what we're asking the court to determine with respect to our taking count on August 18th. If the court renders a determination favorable of liability in Mr. Jameson's favor, then you have an entire jury trial phase where you impanel a jury to determine what the compensation due to the property owner is. The town is expected to take the position that the property is of little value based on how it's applied its wetland regulations. We will look at it from more of a highest and best use standpoint. If that regulation did not exist, what would the property be valued at as developable, just like all the landowners surrounding Mr. Jameson. And so again, they depending on how a jury comes out, a jury of Mr. Jameson's peers, they'll determine what the fair compensation for the taking or the inordinate burden is. And then of course at issue also are attorney's fees and costs. Right. A landowner who presents a claim under both Burt Harris and takings jurisprudence, if they are successful on liability, are entitled to reimbursement of their attorney's fees and costs. And those are significant in this case, given that we've had 4 years of circuit court litigation and 1.5 years of appellate court litigation.
Is there any other indication other than it's wetlands that the town has been given as a reason why they don't want any homes built there? Or is that really you believe that's what it is, the wetlands?
I think that the property has been regulatory mishandled since 1950. The mosquito district dug wetland ditches on the property without paying compensation to the predecessor landowner. Lee County designated it a wetland simply because it had mosquito ditches on the property. No environmental science or study behind that determination. And the town then, as most local governments do when they incorporate, just adopted without scrutiny the carryover regulations from Lee County and identified it as a wetland. Ironically, Lee County and the town at the time of Mr. Jameson's purchase had actually zoned the property RM2. It actually had favorable residential zoning on it, but it was encumbered by the land use regulation of wetland. But again, I've never seen, nor do I believe there exists any wetland, actual topographic wetland delineation at the town or county level that says this property is an absolute unbuildable wetland. And how could it, Ed? I mean, look at the beach from an aerial. It's the hole in the donut. It is a ton of green space surrounded by development. The chapel by the sea is 200 feet south of Mr. Jameson's property. That's a commercial use. The town of Fort Myers Beach Town Hall is 250 feet south of Mr. Jameson's property. It's a public use. There are the Top Supermarket, where it used to be, was just southeast of Mr. Jameson's property. That was a commercial use. If you look at the green space on the beach from an overhead aerial, the only green space that exists is already in public or government ownership, or it's held by a resource conservation entity like the Audubon Society. So every other private property owner on Fort Myers Beach has been able to develop their private property with some minimum economic use, except for Mr. Jameson. And those are the type of facts that we think a court will look on with scrutiny. Look to the west. It's all single-family homes. Look to the right, to the east. It's all single-family homes. They've got docks on the canal, the very same canal that Mr. Jameson's property shares. Was that wetland property? Was that designated wetland ever by any government entity? My guess is no. And so it's questionable.
So different council. The council has been around for a little less than a year now. Has there been any attempt at a conversation with this new council? It seems to me some of the members are less likely to want to be involved in litigation and have the town lose taxpayer dollars that way. Has there been any shot at that?
Sure. So I can't, because we are in ongoing litigation, I can't get into any specifics, but suffice it to say, Ed, we have made repeatedly over the years offers to the town to resolve this litigation, resolve it in terms of both potential development and other non-development avenues, and those have been met with unfavor by this prior iterations of council as well as this one. At this point, I think we're going to need to let a court decide if local government is allowed to just flatly say you can't appreciate any land use out of your 6.5 acres of private residentially platted property. We're as property rights attorneys familiar with the United States Supreme Court law, the decisional law, and it says exactly that. It's a categorical taking if you as local government say you can't build on your property. We like our chances moving forward in litigation. Perhaps something would come of mediation, but at this point, our discussions and our suggestions to resolve this lawsuit have not been met favorably.
So August 18th in front of Judge Laboda, and then there's a chance it could be appealed by either side and go back to the District Court of Appeals in Tampa again for another decision. Is that correct, the way it works?
That's correct. We'll have a hearing in August to see if we can prevail on liability with respect to the takings claim. And if we do, there will most certainly be some type of appeal, I would imagine, by the town. And if we don't, we would proceed then to a trial that is, I think, tentatively scheduled for April or May of next year. And there'll, of course, be an opportunity for mediation in between that. But yeah, if you ever follow any, longevity filled takings cases at the state or national level, they have a tendency to take years, even decades. There's cases that they just seem to go before the trial court to the appellate court, back to the trial court, up and back with pretty routinely. And so, we're prepared for that fight if that happens. But we'll see what turns out.
Well, we sure have learned a lot about Bert Harris and land use regulations and things like that in the last 6 months down on the beach. That's for sure.
Yeah, that's what I've heard as well. Jim's my only case down there with the town. We do quite a bit of work in Lee County, but it's a tough situation. I think to some degree it's been this is how we've done things for a long time, and it's hard for us to now go back and change that. This has been a case that Jim has been battling for over a decade here. He bought it in 2002, 18 years ago, and sought his first real approvals in 2010. And the town has been steadfast that they don't want to see that property built up. Why, I'm not wholly sure. I mean, if I was local government, I'd want the tax revenues from the development coming in. I'd want to see it, in a little better shape than what it is right now, vegetated and sort of, vegetative in sort of disrepair, and you look around that area, it's a beautiful surrounding area. You've got the Sea Grape condominium at the northwest point of Mango Street. That's multifamily development. You've got single family homes to the west, Tropical Shores Way with some beautiful single family homes through there. Again, everybody else has been allowed to use their properties. And for some reason, Mr. Jameson just has not. So we'll see how it turns out.
We'll see you on the 18th, and Judge Laboda's court is in Lee County, correct?
It is indeed. I think at this point we'll probably be by phone or Zoom. Right. The courts at this point, I don't believe, are open for hearings. They're trying to do as much as they can electronically. So it's sort of still to be determined whether we can get in there in person. Obviously, that's my preference. But it's more than likely with the virus and everything that we'll probably be calling in either telephonically or by Zoom. We'll see how it all turns out.
Thanks a lot, Ryan. We'll stay on top of it. Appreciate your time.
Thanks, Ed. Appreciate you having me on.
Take care. Ryan Reese is the attorney for Jim Jameson. And that, for those of you who joined late, Jim is in a lawsuit with the town of Fort Myers Beach over some property that he owns down Mango Street at the end of Chapel. 40 buildable lots is what he says. The town claims that it's wetlands, and it's been a wetland since the 50s. And so they're going back and forth, and the name Bert Harris came up again. We're all getting familiar with Bert. So we'll stay on top of that. The next court date is August the 18th in front of Judge Laboda, who Judge Laboda we also have come to know from other court cases down on the beach. And a reminder, Friday night, we'll be live from Cantina 109 with SouthwestFloridaTalkRadio.com. And our guests on Friday night will be Dane Eagle and Kevin Ruane, Kevin running for the county board. And then on Saturday morning, back on Fort Myers Beach, our guest will be Town Councilman Dan Allers. We'll bring this case up and see if he can talk about it. And also Heather Fitzenhagen. And that's all at 9 o'clock, Fort Myers Beach. Outside of Peach Time Out, table 23. So we'll see you Friday night at Cantina 109 and Saturday morning on the beach. Thanks a lot for joining us, folks, and have a great night.